Hello, Constitutional Law class. This is Professor Opterbeck, and welcome to the review for Week 5. And in Week 5, we continued our discussion of federalism, and we introduced the topic of executive power. And as we continued our discussion of federalism, we talked about the Privileges and Immunities Clause, which we see up on the screen here. And we talked about a few distinctive things about the Privileges and Immunities Clause as part of this sort of sequence of things that we'll look at when we have a federalism question. We noted this applies to citizens only. We noted that Congress can regulate in some ways that states cannot under the Dormant Commerce Clause. But that the Privileges and Immunities Clause might actually provide an additional check on Congress because it may confer affirmative rights that Congress cannot waive. We also noted that there's no market participant exception under the Privileges and Immunities Clause. We did have a test in this United Building and Construction Trades versus Camden case. We noted that in Judge Rehnquist's opinion, he applied the Privileges and Immunities Clause to a municipality. That was actually a somewhat controversial and somewhat unclear part of the opinion, but he gives the test for intermediate scrutiny. So we're going to look at a P&I issue under intermediate scrutiny, and here we have the test on the screen, and this is the test that you're going to want to look at and apply for a privileges and immunities question on an exam or on a bar exam. We then talked about preemption, and we noted that whereas the Commerce Clause gives Congress power to regulate interstate commerce, the Dormant Commerce Clause kind of limits state power to regulate in areas where Congress could regulate interstate commerce and may not regulate. We looked at the Privileges and Immunities Clause as an additional check, and now we're saying for preemption, what is the effect of congressional action on state legislation? In what sense does congressional action preclude, or does federal action preclude state action? And we noted that the issue here really arises from the Supremacy Clause of the Constitution, which makes the Constitution and federal law enacted under the Constitution the supreme law of the land. And what we noted here is that there's three kind of broad categories or kinds of preemption. We have express preemption, where a statute might say expressly that contrary state laws are displaced. And as we noted there, you have to kind of think carefully about what exactly is the federal law in the area and what exactly is the state law, and is it really preempted or not. And then we had these other broad categories. Field preemption, where federal regulation occupies the field, or conflict preemption, which is related to field preemption, but might be a little bit more narrow, where there's, or a little bit more broad, where there's a potential conflict between federal regulation and state regulation. And for all of those, we looked at some examples and noted you really just kind of have to look carefully at the regulatory scheme in question and make some arguments about whether Congress really occupies the field or whether there's really a conflict or not. We then ended our discussion of federalism and moved into the question of executive power. And as we noted, Article 2 of the Constitution sets forth the scope of executive power. We saw in Article 2, Section 1, the vesting clause, and we asked whether the vesting clause is an independent grant or whether the vesting clause only relates to the remaining parts of Article 2, and we noted that's sort of an area of live debate within the jurisprudence of executive power. Under Section 2, we started to look at some of the specific pieces of executive power that are granted in Article 2. And in Section 3, again, we continue to look at some of those specific examples. We started to look at some cases that are playing with some of these pieces of it, for example, under the Reception Clause. And under Section 4, we talked a little bit about the scope of impeachment. As I noted, we went through this question: is Article 2, Section 1 an independent grant, or does it relate to the rest of the Article 2 powers? We then talked very broadly about the scope of executive power and how we figure out some of these questions that might not be immediately addressed in the text of the Constitution itself. And we looked at the Youngstown case. So this is the kind of touchstone seminal case. And as we noted, it's really one of the concurring opinions, Justice Jackson's opinion, that supplies a framework that modern courts are often going to use when they're dealing with questions of executive power. And we noted that in the Jackson concurrence, there are three broad areas. And all of this is relating to the executive in relation to Congress. So if Congress has expressly or implicitly authorized the president to act, Jackson said the president's power is at its maximum. If the president is taking measures that are incompatible with the expressed or implied will of Congress, then the president's power is at its lowest ebb. And we're going to have to try to look carefully and see if there is still something kind of reserved for executive power. And in that middle area, Jackson described as a zone of twilight, where the Congress has not either granted or denied explicitly or implicitly authority to the president. And then we're going to really look at kind of the practicalities of the situation. As we look at all of these areas, as we talked about a little bit, there's going to be a question very often of whether Congress has or hasn't acted either expressly or implicitly. So our first task is going to be kind of an interpretive task of what Congress has or hasn't done. And then we're going to try and figure out which of these categories it falls into. And then we're going to try and figure out how we work out the analysis according to those categories. So we began to look at that a little bit last week. We will begin this week with the example that we kind of ended off with of an internet, a cyber emergency. And then we'll start to talk in depth about some of these areas of executive power, some very interesting, very difficult questions, in particular arising out of the war on terror and the detention of terror suspects and some other issues. So you see a reading up here on the screen. I'm sure you've dove into it already over the weekend, and I'm very much looking forward to our discussions in class this week.